This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hey, everybody. It is your favorite copyright attorney, Leonard French, here at 8 o'clock in the morning where I am, but of course I'm still on US time, so it's 2 o'clock in the morning, so you know how much I love you that we are going live here, and I am unshaven, and I've got old man zits on my face. What? These things are supposed to be going away as you get older, people. I don't know what's going on. But I was alerted. I was alerted by your many emails and tweets and emails and contact forms on my law firm website that apparently something has happened to a channel called MxR Plays. So I've spent the last half an hour watching MxR Plays videos, including their, I guess their red flag or their SOS flare. And I thought we should talk about the injustice of copyright. Now, I'm going to need your help with this, audience, because I have not seen all of MxR Plays videos. However, let me first say, they're really funny. They're pretty hilarious. They're doing the male-female, cute. I think they're a cute couple. I think they're a couple. I don't know. I don't know them. I'm not claiming to know things I don't know, but they seem really cute together, and they're really good at making jokes. I don't know if these people are professional comedians or not, but they're professional comedians in my mind, and it sounds like an H3H3 situation at the first glance. So let's see what in the world is going on here. Let's see who could possibly help these people, or do they need to pay up? I have no idea what the answer is going to be, so we're going to go on this adventure together. So, first of all, audience, could you tell me a little bit about MxR Plays? You guys have seen the H3H3 stuff, I think, maybe some of you. And the H3H3 stuff was very much a limited commentary on something. They would make limited use of Matt Haas's video, for example, and then they would comment on it and things, and that's what was called a quintessential fair use. And what I'm watching MxR Plays do is something very, very similar to that. They seem to go on to a site like Reddit for the one video about what things are asked, what questions shouldn't you ask to a man or whatever, which was hilarious, by the way. Go watch the video. They're just a couple of friends, right? Yeah, they're just a couple of friends who are munching on each other's pasta. They made some really good jokes. Really appreciate that. But is it copyright infringement? Is the game we're going to play today? Now, a couple things before we get started, so I can fill some airtime while you're all getting filtered in. Copyright infringement is a strict liability offense. Now, I'm going to treat you like a client. These are not my words. I'm saying the words, but this is the law. I'm not here to tell you should obey I'm here to tell you what the law is and not whether I like it. I'm going to talk about whether I like it, but please don't misunderstand when I say it's a strict liability offense. I'm not saying I like that. I'm not saying that that's a good idea, but it is. The way the law is written, it's a strict liability offense. What the hell is a strict liability offense? You normally have something in the criminal code. Yes, criminals get colds too. It's cold in those jail cells. In the criminal code that says that you have to have some kind of mens rea, which that is not anything to do with anyone's time of the month. That is what is called a criminal intent or a criminal mind. For many different kinds of crimes, and this is not what I'm calling a crime, as MxR Plays thing on MxR Plays end. It could be a crime on the other end. We're going to go over that. When you don't have criminal intent, it is much harder to find someone guilty of a crime. However, copyright is not a crime in this sense. Copyright infringement is a criminal offense. You get the FBI warning and all that stuff. That's not what we're talking about here. No one is being charged with a crime, and no one will be charged with a crime. There's nothing that I saw from MxR Plays that would indicate to me that they've committed the kind of copyright infringement like copying someone's movie and then bootlegging it en masse. That's the kind of thing that might get the FBI's attention or get Customs and Border Protection attention. This is not that. So we are not talking about a criminal charge or a criminal intent. So their intent does not come into it at all, except in one very specific case of copyright damages, which I'll get to, called innocent infringement. All right.
The gentleman from Illinois would like to read something for you.
Yes. Go ahead, Brandon.
The Poet of Fall says MxR is more of a meme reviewer than a reactor. His show is him and his girlfriend looking at...
Sorry, real quick. Do not drink orange juice right after brushing your teeth. Sorry, just life pro tip there for you. Go ahead, Brandon.
Leonard,
sorry.
Everybody knows that.
Well, I just reminded myself at 40 years, nearly 40 years old.
Were you today years old?
And not only that, I'm going to do it again. Oh, that is horrible.
Why are you doing this to yourself? At least let the mint go away before you start drinking orange juice.
Oh, that is horrible.
MxR is more of a meme reviewer than a reactor. His show is him and his girlfriend looking at memes, Reddits, etc., sort of like PewDiePie, like his meme review channel.
Okay.
Or shares. It's more transformative than a stereotypical React channel, since it doesn't just rip a whole episode of something and react to it. They source content on Reddit and then comment on it.
Okay, source content on Reddit and then comment on it. That sounds very much like a fair use. So where are they living? I don't mean the geographic location. I mean in the legal spectrum. If there's a bright line in the middle someplace, if we just think about it that way, if there's a bright line in the middle, it's a bright line in the middle. And if you're on one side of the line, great. If you're on the other side of the line, you're screwed. You don't want to be right on the line. So we're going to try and figure out where the heck they are. So a couple reminders. You don't have the right to use other people's content unless you make a fair use of it or you have permission. Those are really the two major ways that you can make use of someone else's content. So I'm going to assume right off the bat they don't have permission. So that's not a problem. You just make a fair use, right? Well, fair use is this 4-factor analysis. I said factor, not element for you law students. It is a 4-factor balancing test. And one of the things we all more or less hate and love about copyright is that we have fair use. Because fair use is a balancing test, it is a legal analysis, and it must be done for every single piece of content you use. We would have to go through every single one of these instances from MxR reviews or MxR plays. Now, they do have in this picture here the URLs of the video. So how long are these videos? Can we OCR this? Does somebody have the ability to OCR this thing and get these 4 videos out of this thing? How do I do this?
OCR, I can download them.
If you could, what do you mean download them?
What do you mean by OCR?
I need to get the links out of this thing. Where are the links to these 4 videos? So let me work on that. Somebody work on that while I try to talk about fair use and also work on it at the same time.
Yeah, talk about fair use. I have your stream paused. I'm going to get them for you.
Okay, great. So fair use is a 4-factor balancing test, and it only allows you to use someone else's content if you actually make a fair use. H3H3 was only in the clear because they made a quintessential fair use by following the 4 factors. And so we've got to apply these. I'm not saying whether MxR plays is right or wrong here yet. I'm saying we have to apply these. So let's talk about them first. Real quick, the first factor is the nature of the copyrighted work, and it's a transformation factor. It's whether or not you have wholly copied a work, or whether you have transformed its purpose and its character in some way. So we look at the original work and compare it to the new work. Let me think of an example here at 2:15 in the American morning. if so, the direct example was I was going to think about was the H3H3 example, of course, but let's sort of back off of that. I'll use a completely different example and try to bring it back around. Think of someone like Greg Gillis and Girl Talk. He uses, and his group uses, the very heart or core of some music samples, but they use a whole bunch of them and make a completely new work out of tiny pieces of old works. And as far as I can tell, he has not been successfully sued for it. Literally taking samples, which would normally be per se copyright infringement, but rearranging them in a way to create an entirely new work with new meaning and new understanding and new art and new purpose. That was copyright transformation. And I'm not speaking in legal advice terms here. I'm speaking off the top of my head. So no lawyer would ever do an analysis like this right before they go into court and say, oh yeah, I briefly looked at the situation and I know everything I need to know. So let's first acknowledge that, you'd have to look further into each one of these. The second fair use factor is the commercial purpose of the copyrighted work. Commercial purposes will get, or commercial fair uses will get less fair use recognition than, say, a fair use for a purely educational nonprofit purpose. Those are two ends of the spectrum. So if you are making a pure commercial use, that's going to get less protection than if you are making a purely nonprofit educational work. But if you're somewhere in between, it's a spectrum. It's a balancing test. The court or the judge or the jury, if it ever got there, you don't want to put these kinds of things in front of a jury. Juries don't understand this either. So if you are making a use somewhere in between there, it's going to get the appropriate weight for something in between there. The third factor is how much of the original was used in relation to the entirety of the original, how much was used in the new or fair use work. One of the main reasons why H3H3 was found the way it was, that they were a quintessential fair use, is because they made a use of a minimal amount of Matt Haas's video. Even though they used a significant part, they only used what they needed in order to make the commentary. This again exists on a spectrum. Think of the Mystery Science Theater 3000 situation. Now, Mystery Science Theater 3000 had licenses, still licenses their material. They originally had licenses from KTLA TV, and there was no problem with them doing whatever they wanted. Well, Mystery Science Theater 3000 played the entire video while making commentary on it, or played the entire movie while making commentary on it. So if we just take that scenario and take the fact out of it that they had licenses, would it have been a fair use? No, it would not have been a fair use because they played the entire movie. Even if you made commentary on the entire movie, you still played it from front to back. And then that gets you into the fourth factor, which is the market usurpation factor. A weird word, usurpation. I just go around, I say that to my girlfriend all the time, like, I'm going to usurp you. No, market usurpation is when you substitute, when you act as a valid market substitute. Can I go and watch an MxR video and not have to go look at the original? And then so we have to ask ourselves all these questions. So I'm going to think about this now in the context of the video I just watched, which was the what you should never ask a man or whatever. It was a really funny video, by the way, but let me tell you what I saw. I saw them going onto Reddit, and I saw them showing a title from a Reddit post, and then asking themselves a bunch of questions and then answering them in a very comedic and funny way. So first, there's a kind of a weird copyright exception you should know about. There is no copyright in titles. So if someone titles a movie, You've Got Mail, well, technically anybody can title anything they want. You've Got Mail. It doesn't, just because a movie was made with the title You've Got Mail, I'm dating myself here, doesn't mean that you can't go and make something with the same title. You still have to do the rest of the copyright infringement analysis. It's not like you can go post the Meg Ryan, Tom Hanks movie, You've Got Mail, but you could use the title. There's no copyright in titles. So when I see them showing a title from a Reddit thread, I'm not even sure that counts as copyright. But I'm assuming that's not what we're talking about here with this Jukin Media settlement demand. Oh, you know what I just noticed, Brandon? There's actually names on these videos. We could have just searched for the names of the videos.
Well, I've already gotten the links. They're in tip staff for you.
Okay, let's see here. Now, see, I've got to do the same thing. I've got to make sure that I don't commit copyright infringement. So I'm going to look at, let's see. An attractive woman was arrested. This is her ridiculous response. Let's try that one. And I've got to be very careful here. So hang on a sec while I figure this out. Because I'm on a live stream, right? I could very easily commit the exact same kind of infringement.
Gee, what the fuck?
All right, so I'm going to turn off the sound here for a second while I find the video on, you know, whatever segment that might be talking about. Do we know, is there like a timestamp on this thing over here? No, there's no timestamps on these things. Oh, and these titles are different, by the way. So hopefully that's not a problem, but we'll see. Okay, so an attractive woman was arrested. This is her ridiculous response. Here's a still frame. Because again, I want to make sure that I'm not going to get myself in hot water with Jukin Media. But they appear to show clips Are glasses actually eyes? So they seem to be a clip reaction channel. And I'm gonna take this off the screen for a second so I can just play it. So here's a guy who throws a firecracker in the ground. Oh, okay, I think I've seen this clip on Reddit. This is where he has a gas leak and his backyard blows up, and they react. And then afterward...
No, I'm pretty sure there was a pipe underneath.
Oh, Ginny's smart. I'm not.
That runs underneath.
Yeah, I'm pretty sure Ginny, he just tried to, like, set an explosive off.
He put propane in there?
Okay, so they are clearly showing a video and then reacting to it. Here's the actual Reddit comments. And okay, so this is what I was concerned about before. They're living sort of right on the line, and if I may be so bold, they and I are doing the exact same thing, except they're doing a much better job of it. I'm doing it though on a different source of material. We at Lawful Masses take a look at court filings and other public domain material, and we are very, 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 very careful to make sure that we are on the very clear side of the line, that we are not committing copyright infringement. And arguably, there's one or two times we have shown something that might have been too much. There was one time that we talked about the Area 51 thing, and we used a fairly good bit of a TV station's interview with the Area 51 people, and in the edit, I decided to cut it down a whole lot because I was very concerned that a TV station's interview video might not actually be a fair use for me to use. Why? Because I wasn't commenting on the TV station. I was commenting on the interview that was in their content, and I didn't feel that was exactly a fair use. So if MxR Reviews or MxR Plays is using this material, they have to make sure to clear every single one of the copyrights. And this is the injustice of copyright. It gets very expensive, and it makes small-time operations very, very difficult. So I was watching their 5-minute announcement video about how someone goes through all of these videos and searches the internet for where did these videos come from, who owns the copyright, and decides whether or not they can use them. Welcome to the injustice of copyright. So we have a couple problems here. We have the orphaned works problem. This is if you talk to attorneys about who know copyright and you mention orphaned works, you'll get a collective sigh and eye roll, because none of us really know how to solve this problem in a fair way that everyone will be on board with. You try to solve this problem and you get half the people hating you. So what is the orphaned works problem? Well, in copyright, you need to make sure you have the legal rights to use whatever you were going to use, whatever third-party content you're going to use, content you didn't create from your own whole cloth. Like, this video with me, my face here, I'm creating this is fine. I can do this all day. Of course, that's not going to get the same number of views. Nobody wants to see my face. They want to see funny content like MxR Plays does. Well, unless you clear the copyright by having authorization, you must be using it as a fair use. Otherwise, you're taking a great chance. And a lot of companies, a lot of people, a lot of YouTube channels, a lot of memes, a lot of internet users, just people do this all the time and nobody gets in trouble for it. So why MxR Plays? Well, I think they've correctly identified that it's probably some sort of extortion or aggressive legal claim. Where was I? I totally lost my train of thought. Where were we in my discussion here, Brandon? Save me while I have another swig of my thing.
Fair use. Talking about how we use content.
Right. How we use content. Yeah. So I totally lost my train of thought here when I went over to extortion. I switched topics to extortion, and now I've forgotten what I was saying. So they're living on this the orphaned works problem. Thank you. So the orphaned works problem then comes into this. When you go to clear a copyright, how do you know who owns a video on the internet? This is incredibly hard in some cases. A video may have been posted a million times. The original may have been deleted. It may never have been uploaded with authorization in the first place. There may be no way to find the owner of said video. But copyright still recognizes the ownership of that video. Someone still owns the original copyright on that video. And if they go so far as to follow the rules of registering a copyright, then they can go and sue on it. However, what has MxR Plays received here is a demand for payment. And the demand is for $1,500 for each video that allegedly used content. I think both parties are existing in the middle of this spectrum of fair use and not fair use, or extortion or not extortion. Now, what is extortion? Extortion is when you make a claim to something that you don't have a legal right to do. There was recently a case where we're going to go over this on our channel probably later today. Maybe it'll drop for tomorrow. But there was a case in Florida where a man obtained 2 years of sales records from a car dealership. And these sales records had customer information on them, including their financing applications. So you go to buy a car, you fill out things like you would for a credit check, right? And so you've got your social security number on there, you've got your name and address, you've got your birth date, you've got everything somebody needs to take out a car loan. This is PII. This is personally identifiable information. This is private information that is protected by law. So this person somehow obtained 2 years of sales records from this car dealership, likely illegally, and then told the car dealership that they had demands. Give us a 2019 Chevy Malibu and $50,000. That's extortion. The person has no legal right to make that claim. They are simply demanding something from someone, or else they're going to do something illegal, like release the sales records, or they otherwise don't have a legal right. However, let's flip it a little bit. Let's say the car dealership committed copyright infringement against the person, and the person hadn't stolen any sales records, and they turn around and say, give me $50,000 and a 2019 Chevy Malibu, or else I will sue you for copyright infringement. That's just aggressive legal action. That's not extortion. So if Jukin Media has an actual legal claim, then it's not extortion. And if they don't have an actual legal claim, then it's going to be somewhere on the spectrum between extortion, if they knew that they didn't have a legal claim, and just aggressive prosecution of copyright infringement that turned out not to be copyright infringement. So we have to do this kind of fair use legal analysis for every single use of every single third-party video. And MxR Plays is a great channel, it looks like, but they also have this duty to clear every single copyright that they have ever used. So for every Reddit post, they have to figure out, okay, who owns this Reddit post? How much of this Reddit post can we use? How much commentary can we make in order to create a fair use? And how do we do this without also getting false claims like this from companies who are going to take advantage of the copyright system? Now, if I had my way, these people would take this to court and we would get an answer in court. In court, really all that's at stake is legal fees and copyright damages. And copyright damages at this level, I feel, are going to be relatively low. Copyright does come with a $150,000 penalty for a willful copyright infringement of the worst kind. And I don't see this as anywhere close to the worst kind of copyright infringement. $1,500, maybe a little bit more, sounds more like what a copyright judgment might actually be. If they were actually successfully sued for copyright infringement, yeah, $1,500 or so might be something a judge would find. $1,500 is only 2 times the minimum copyright damages. So $750 per title is the minimum copyright damages, except that I mentioned something called innocent infringement. Then there's something called innocent infringement, where if you can show that you did your very best to find the ownership of the copyright, that you did a fair use, that you really thought that you were on the safe side of the line, and this was a genuine and sincere belief, and you have to convince a judge or jury of this, then the fine is $200, or the penalty is $200 per infringement. The other trouble, though, is that copyright has a fee shifting provision where if you lose, they get to ask for their attorney's fees. Now, we have ways of heading this off, but if you leave this unchecked and it runs rampant, you could find yourself on the hook for a lot of copyright, or rather a lot of attorney's fees in a copyright case when the actual copyright damages are small. A couple things about those damages. Statutory damages versus actual damages. There's a provision in copyright law that separates different kinds of damages depending upon how you have registered your copyright. So let's assume that Jukin Media has the ownership rights to these videos. Have Jukin Media registered these copyrights? If they are not registered with the Copyright Office, they only get actual damages. They only get provable actual damages. So they have to show a history of receiving licensing fees, how much those licensing fees were, actually collecting on those licensing fees, and what they actually collect divided by the number of copyright claims will be round about what a judge might grant. That usually would be about $300, $500 per video or per use. It depends upon the size, though. I see 633,000 views here on a December 9th, so in 1 month they've gotten 600,000 views on a video. Maybe the damages for licensing fees are a little bit higher because it's a popular use or a popular thing to license. But Jukin Media has to register the copyright before they can sue. And then they have to wait like 5 or 6 months for the Copyright Office to get back to them with a completed registration. Then they can finally sue. However, we've got this stupid law that needs to be updated for the times. It's called the DMCA, the Digital Millennium Copyright Act, 17 U.S.C. 512 and 17 U.S.C. 1201. We're not going to be talking about 1201. That's circumvention of digital rights management stuff, basically. And 512 is more so where the DMCA takedown provisions are. So is it legal to demand a $1,500 license fee or else we strike your channel? That's really coming close to extortion, even if there's underlying copyright infringement. It is certainly legal to send a DMCA takedown notice, but in that DMCA takedown notice, you have to profess under penalty of perjury that you have a sincere, good faith belief that the material underlying is infringing. And saying, we want $6,000 or else we take you down, is not going to play well in court. Imagine a plaintiff's attorney bringing an action in court and then saying, yes, Your Honor, my client did set a demand that they're going to end these people's career unless they pay up. That doesn't sound very nice, does it? That doesn't sound like people trying to resolve a sincere copyright claim. That sounds like extortion. So I'm already kind of on the side of MxR Plays on that one. And the second thing is, the damages would only be for actual damages unless they can show registration of a copyright. Now, I'm no stranger to the internet. I've got a couple of my own videos licensed to Viral Hog. No, it was not a good idea. Don't do that. Don't don't sell your video to Viral Hog unless you really know what you're doing. So these things don't happen with copyright registrations very often. I don't imagine that people sell a video to Jukin Media and Jukin Media immediately turns around and goes, you'd better make sure you register your copyrights at $55 a pop in order to help us prosecute copyright infringement on your behalf. I don't think so. I don't think that happens. I am not saying it's not possible, and you definitely must look into it in every single case. But I don't think it happens. So I don't see how they would be able to get anything out of MxR Plays besides a licensing fee if a video was not fair use. So what MxR Plays should really do, and this is not legal advice. There's lots of unknown information here. In order for an attorney to give legal advice, the attorney is supposed to do due diligence, DUE, due diligence, the diligence that is due to the situation, and we have to investigate. So if I was representing MxR Plays, or if Nick Rakita is going to represent them, or if Legal Eagle is going to represent them, or if Steve Lato is going to represent them, Kurt Mueller cannot represent them because he's an attorney with the U.S. Patent Office, and so he can't represent anybody. He's represents the government. If any of these attorneys were going to represent MxR plays, they would do a much, much deeper analysis than I'm doing here. In fact, I don't even know that any of us could do a live analysis on a live stream properly. It would involve us making not fair uses, because I'd have to play entire videos, I'd have to watch entire things, I'd have to scour the internet for these videos and watch the entire thing. So I'd have to do that all offline. I don't even think you could do it on a live stream safely. If we did our due diligence, we might be able to answer the question more clearly. But if you remember, just the simple use of Matt Haas's video on the H3H3 channel required $150,000 plus of attorney's fees and what was it, a year and a half of time, and the judge devoted some 20 pages or so to explaining that one fair use. That's the level of analysis we have to go through to make sure that we know which side of the line this falls on. And so that's first of all, that's why I will not be able to give you a judge's answer here. But this is the analysis we have to go through. So can you look at a Reddit post? Can you react to the Reddit post, make jokes about the Reddit post, and move on without it having be copyright infringement? I think you can, but you have to be careful what you're showing. In this particular frame, for example, they're showing people's comments. Well, those comments are technically copyrighted. However, they're not owned by Jukin Media, so it's not really a big deal, and I don't think anybody really cares. But let's say that you wrote a nice comment or something, a big comment. Let's say that you published your book in the comment, and they put that up on the screen, and we're like, here, let's read this wonderful story we found on Reddit. No, that's probably not a fair use. If I posted something, a short story on Reddit, and they just went and displayed the short story and read the short story, that's copyright infringement. But that's not what they're doing here. They're showing it, they're reacting to it, they're commenting on it. So that's at least very close to, if not on the line, maybe even over the line, into fair use. But Leonard French, you're doing the exact same thing. You show court documents in their entirety, and you just read them sometimes. I've definitely been accused of, why can't you do something more interesting than just read a court document? Well, sometimes it's just a public service announcement. Sometimes we just want to show you what a judge said, and then I'll go over it a little bit. But why am I on the safe side of that? Because that's public domain. That's not copyrighted. That's not able to be copyrighted. Court opinions and attorneys' filings, and sometimes even the demand letters they send, they aren't sent for the purpose of copyright. So I'm definitely changing the purpose and character by going over the legal ramifications of something. I don't even really need to know fair use law for what I'm doing on lawful masses. I need to know fair use law for stuff like this, when you guys wake me up at 8 o'clock in the morning in Luxembourg. By the way, I'm on US time, so I sleep till noon here. So if I look a little bit tired and seem a little bit out of sorts, that's because you all woke me up with blowing up my email and Twitter and everything. So let's go a step further. If they show the guy with the propane thing in his backyard blowing up, this guy, if they show this guy, what happens if that video is licensed by Jukin Media? Well, now you've got a bigger analysis and a bigger issue. They definitely showed the whole video. They showed the guy trying to put the match into the ground. They showed the thing blowing up. They basically showed the whole video. So that's not going to look great for fair use factor number 3, which is how much of the video did you use in relation to how much of the video did you need to use. However, the third fair use factor doesn't immediately throw out the other 3. It is a balancing test. It's like people standing. You ever see that video of those 20-some old men trying to balance on a giant log? It's a seesaw in the middle of the woods, and one of them shuffles a little bit wrong and starts to fall, so the whole thing gets off balance and ends up throwing all 20 of them off the thing. Kind of funny. I hope nobody was hurt. They're all relatively old men. I would expect someone could have been hurt seriously in that. But, it is what it is. It was funny for what it was. This is a balancing test. And the third fair use factor does not automatically throw out the other three. So if they have used the video in a way and they've made a new creation out of it, transformed the purpose and character of it, then the first fair use factor will go in their favor. Well, have they done that here? They've commented on it. Okay. Has their commentary transformed the video? Does a reaction and comedy about a video transform the underlying video into a new work? Well, arguably, yes. But it's arguable, not clearly. If they took this video, let's take it further. Remember, we play the game of hyperbole to find the extremes, not to be extreme, but to find the extremes. So if they took the video and made it part of a collage of videos that they zoomed out of the video and they made the video's this tiny on the screen and there's a million other videos on the screen and they're all playing and they make a funny face or something like that, that's transformation. That's not the only kind of transformation. If they were making a fire safety video about not lighting things on fire when you smell gas or something, fire safety video out of this and showing this as an example of what not to do, much more transformative, right? Just showing someone's video and laughing about it and making commentary about it and making comedy about it is less transformative. Again, it's a spectrum. It's a balancing test. I'm not saying they aren't funny. I'm not saying it isn't commentary, but it's less transformative than something more that I was explaining. And then it's for commercial purposes. I'm assuming their channel is monetized, or they wouldn't be upset about being demonetized. Or it certainly would be upset about losing their channel, but I'm just saying there wouldn't be so much upset about being demonetized unless they are commercial, making a commercial use of this video. And remember, we're talking about this video here, this one with the thing blowing up in the backyard. I don't know if this is the video that Jukin Media owns or not, but that's what we're talking about. And then I already said the third fair use factor was how much did they use, and they used most of it. It seems like they used the whole video. I don't have to go watch this video on Reddit now or wherever it's properly posted, wherever its owners posted it. I can't go watch. I don't have to go watch that because I watched it here. They've even got themselves in the bottom corner. It's not them over top hiding the video from your views. It is in the corner so you can see the entire underlying video. And is it usurping the market? Am I now intrigued by their reaction and I want to go watch the original video, or do I not have to watch the original video because I saw theirs? And I don't have to go watch the original video because I already saw theirs. I saw the thing blow up. There's a couple further things, though. I mean, maybe this is blurry. Maybe this is in a lower resolution than it was originally. That doesn't change it much, but that's certainly something a defense attorney could argue in court. But maybe it's blurry, maybe it's zoomed out, maybe something has been altered about it so that it's not the same as the original. It's less usurpy. So if you have lowered the resolution, put it in the background or something, that's less market usurpy, but it is still on the spectrum of market usurpation. And so if you went through a 4-factor fair use analysis for this one clip, you might be on the line of fair use. You might not have a fair use on one hand, and one set of arguments, and they could very easily fall on the other side based on the arguments, basically. So these people, this channel is existing, at least in this particular clip, right on the line of fair use. It's not clear to me whether it would be found a fair use in court or not. So I'm going to conservatively then, as an attorney, I would say you want to fall on one side. You want to be safe. You want to be better safe than sorry. You don't want to be on the wrong side of the line. So you make sure that you're on the right side of the line. And so if you're living right on the line, I'm just going to go straight to damages. Like, can we talk about what the damages might be and how hard it's going to be to get there? If MxR Plays got 4 of these kinds of on-the-line copyright claims, the next thing to do is to call their bluff, call Jukin Media's bluff, and force them to take the matter to court. You would want to hire a copyright attorney who will do the due diligence of looking at these 4 claims and deciding whether they are a fair use or not. You would want this attorney to be eminently familiar with fair use. You'd really want to hire the best attorney you could afford. And I'm not saying that's me. I'm over here in Luxembourg, and if they hired me to do this, I would have to get paid a fairly decent amount of money because I'm going to be putting in a fairly decent amount of time and taking a bit of risk in having to fly back to the States and represent them if this thing goes to court. But there's a couple court options here. So when you get a DMCA claim, which this is not, this is pay us or we're going to DMCA claim you, you do have the right to dispute the claim. And the DMCA says that if, well, actually, let's go over it. You know, why you just don't have to take my word for it. Let's just go over it. This part is not even fair use because I don't have to worry about it. Here you have the Cornell Law School Legal Information Institute. This is 17 USC 512, limitations on liability relating to material online. And this is, so A here is for service providers, B here is for service providers, C here is for networks, D here is for location tools, F here is for representations. So this is one of the things, we'll skip ahead a little bit and then I'll fall back. Misrepresentations, any person who knowingly, materially misrepresents under the DMCA takedown section, that material is infringing, is liable for damages, including costs and attorney's fees. However, it also includes people who misrepresent that they own copyrights or have fair uses or are made fair uses when they have not. But it must be a knowing misrepresentation. And this is key. I have one A court case based on the knowing misrepresentation standard. Knowing means actual knowledge, should have known, or willful disregard, or willful blindness to the knowledge that someone is either infringing or that you have a fair use. So they just have to have a sincere, good faith belief. That's the actual legal words. They have to have a sincere, good faith belief that the material was removed by mistake, disabled by mistake, or misidentified by mistake in order to be clear on this. So great, there goes my one light. How do I look? Good job, Leonard. I'm okay, I'll live. Then, if a party has made said knowing material misrepresentation, then they can get their costs and attorney's fees and damages back. So that's great, right? No, that leaves a giant line where Jukin Media could make a false claim that Jukin Media sincerely believes is not false, or MxR Plays could make a incorrect DMCA response, and neither of them could fall under this law because they both sincerely, good faith believed that they were not infringing on any material, or they were not infringing, or that MxR that Jukin Media had a license. Damn it. Let me think. Use my words. It's too early in the morning. Or that Jukin Media owns the copyright. So this then, DMCA 512G, replacement of removed or disabled material and limitation on other liability. There's no liability for taking down. Okay? Well, that's YouTube, right? We're talking about YouTube here. The service provider shall not be liable to any person based on the service provider's good faith belief in disabling access to removal of material or activity claimed to be infringing, or based on facts or circumstances from which the infringing activity is apparent. So we're not worried about that. They're talking about any claim that material or activity is infringing. The DMCA 512G is the safe harbor provision. This is what we call the safe harbor provision. YouTube will not be liable. YouTube shall not be liable to any person for following this procedure. They will not be liable if, upon notice, they take reasonable steps to promptly notify a subscriber that they have removed material, and upon the recipient of the claim's counter notification, they promptly provide the claimant notification and inform them that the material will be replaced after 10 business days. And if they then remove the material and then replace it after this notification and counter notification process. Now, this hasn't happened yet, right? This is the threat. The threat is that MxR Plays will receive a DMCA takedown for each of these videos, and those takedowns will result in the termination of their channel. That all by itself is supposed to be how the law works. But then what YouTube does that is especially egregious is they levy a copyright strike against your channel in order to avoid themselves having to be liable for your alleged copyright infringement. And YouTube is a third party in this analysis. They also don't want to be on the wrong side of the line. Why? Well, look at the Cox case. COX. Cox is a service provider who allowed their users to commit copyright infringement and did not observe the DMCA takedown notice policy. They allowed users many opportunities to receive notice of copyright infringement and yet continue to infringe, and they did not implement a termination policy, which is their version of a takedown. The service provider in the ISP's case, in Cox's case, can't take something down. You're just sharing a file or whatever. They can't really take it down. Instead, they get notices of copyright infringement. Those notices are not then legally acted upon by going to court and getting some kind of judgment. So instead, the service provider, the ISP, looks at or treats this DMCA claim as valid. And if you get 3 of them and you ignore them, they're supposed to terminate your account. YouTube is doing the same thing here because Cox was hit with I believe it was a $1 billion judgment for not terminating accounts after wanton copyright infringement in mainstream music. Users would receive sometimes more than a dozen DMCA takedowns on separate occasions. They would get notice to the ISP would give notice to the person, the user of the ISP's services, the internet subscriber. They would send notice, and then it would still happen again. And they would send notice, and it would happen again. They would send notice, and then they would never terminate somebody. and that got Cox a $1 billion judgment. And now YouTube just got a $170 million judgment for disregarding the Children's Online Privacy Protection Act law. So YouTube is especially sensitive to not wanting to get a $1 billion judgment against them, let alone a judgment for MxR plays, fair use or not fair use or whatever. So when Jukin Media sends a DMCA takedown notice, YouTube must obey it. YouTube doesn't want to do this analysis for MxR Plays videos every single time. It's not YouTube's job. I would love for it to be something that they can figure out how to do, but I'm also the one who is complaining about the adpocalypse and Content ID and their use of AI in a fairly unfair or incorrect manner. Demonetizing videos just because they see a word in the title or something that they don't like, or because it's an LGBTQ plus video, just automatically gets demonetized. There's even a lawsuit over the demonetization of LGBTQ plus videos because that's a protected class. You're not supposed to discriminate against people based on their sexual orientation. So when Jukin Media sends a DMCA takedown notice, YouTube has to obey it. If they do not obey it, they risk being responsible for the copyright infringement themselves, liable for the damage that we're talking about here. So YouTube has to obey that process. But here's where it becomes even more unfair. Many times YouTube doesn't honor the second part here. YouTube has started not observing the counter notification process, which is also supposed to be as clean and clear as the original takedown process. YouTube is not supposed to be doing a legal analysis of every single DMCA takedown, and they're not supposed to be doing a legal analysis of every single counter notification. So YouTube should instead receive a counter notification, which is what MxR Plays would do if they thought they had a fair use and had received an actual DMCA takedown, which is not what's happening yet. They're just receiving the settlement demand, a cease and desist or settlement demand of a kind. And then when MxR Plays, when Jukin Media turns around and says, pay up or we strike your channel, that starts to look a little bit like extortion, especially if they don't actually own the right to sue, or especially if MxR Plays is making a fair use. But let me continue with this. If MxR Plays writes a counter notification, then YouTube must replace the removed material within 10 business days. Now then, I don't know exactly how YouTube treats the copyright strike then, but the way it's supposed to happen is then the matter goes to court. Not automatically, but rather it's left to the parties to work it out in court, and YouTube is supposed to now be out of it. They leave the video up, they should leave the monetization up, and just let the parties figure it out. At that point, really all we're talking about is money. We're not talking about striking people's channels and everything at that point. But YouTube does it anyway. YouTube will probably still maintain some kind of strike on the channel, maybe even fully demonetize the channel, maybe even take down the channel if they receive enough of these while it's all being worked out. So the channel could go down for 10 business days under this law, and maybe even longer because YouTube tries to be so safe on one side of it that they favor the claimant over the channel. And then here's C. If the service provider replaces the removed materials in not less than 10, not more than 4 business days, unless they receive notice from the original person that they are seeking action in court. So you write a DMCA takedown, then someone issues a DMCA counter notification, then the original claimant has to go to court. I think we saw this a little while ago when a Japanese company went straight to court to do this, and issued, they did this process where they issued a takedown, they got a DMCA counter notification, the material has to go back up unless you get a court order, and they went straight to court and got a court order. To write a counter notification, you follow part 3 here. You have to have exactly these things, a physical signature, electronic signature, identification of the material, usually with a link. You can't do it without a link. You have to say the words, I state under penalty of perjury that I have a good faith belief that the material was removed or disabled as a result of mistake or misidentification. And then you have to provide yours or your attorney's name, address, telephone number, and a statement of consent to federal district court jurisdiction for where the subscriber or why are they using subscriber in here? I guess they're service provider subscribers. The channel in this case, where the channel consents to district court jurisdiction. A service provider's compliance shall not subject the service provider to liability for copyright infringement. That is why YouTube acts so aggressively in response to this. And that is what enables extortion of this kind. So, can we call it extortion? Is it even extortion? Well, if Jukin Media knows that MxR Plays is making a fair use, but they have reached out to them with a demand and a claim anyway, yeah, that's extortion. But if they have a genuine, sincere, good faith belief that MxR Plays is not making a fair use, then it's just a copyright claim. Then it's just a legal claim. And the difference, of course, is huge. It's the survival or not survival of channels like this and this particular channel. So let's see. Let's continue just with our DMCA analysis real quick. You can also get a DMCA subpoena, which is not what's happening here. That's to identify an infringer. That's what's happening in the Watchtower Jehovah's Witnesses case against a Redditor. We're still waiting to hear what the outcome of that's going to be. This is injunctions. You can get an injunction against a service provider from providing access to infringing material. And so that's something that can happen. The court can consider things about injunctions. We're not really too worried about that. There's definitions down here. I don't think there's anything else really in here that we need to talk about. No. Okay. So what happens next? Well, MxR Plays needs to decide whether they pay up or maybe even make a counter offer. Maybe they offer a few $100s per video instead of a few $1,000 or $1,500. Maybe they dare the Jukin Media Group to issue these DMCA takedowns, and then they immediately turn around and issue counter notifications and just deal with the damage for 2 weeks, keeping track of their losses, keeping track of their attorney's fees and any other costs. And maybe they then turn around and sue if Jukin Media does not. There's two options there. If MxR Plays issues a DMCA counter notification, YouTube needs to obey that. But we also know that sometimes YouTube doesn't obey that. However, YouTube has been not obeying DMCA counter notifications mostly for music industry stuff. As far as I've seen, and it's my suspicion that YouTube is indemnified by the major music industry, YouTube will only do that for music industry stuff. That's my guess. That's just a guess. I could be completely wrong. Do not hold me liable. They could be doing this for more than just the music industry, but I think it's the music industry. When people use music in the background of a video and they don't pay for it and they're just counting on getting a monetization claim, well, sometimes YouTube gets a DMCA claim instead of a monetization claim. And that DMCA claim many times people will simply issue a DMCA counter notification and dare the music industry to take them to court. Well, if YouTube recognizes the elements of that situation, they often just side with the music industry, because who's going to sue YouTube? The music industry. You're not going to sue YouTube. I'm not going to sue YouTube. The music industry is going to sue YouTube, and they're going to get a $1 billion judgment like they did in Cox. So YouTube is very concerned about getting that kind of claim. This isn't that. As far as I can tell, this is not a music industry claim. So I do not think that YouTube will disobey the counter notification process, but that is just a guess. They still could. But if they don't disregard the counter notification process, then all MxR Plays has to do is issue a counter notification and wait and hope and keep track of things, and cast their videos on some other platform, or figure out a way to diversify if they haven't already. By the way, that's how you protect yourself from some of these things, is you diversify. We are now going to be on Floatplane. We are on Twitch. We have Patreon and Sponsus. We are on YouTube, of course, but we have our own website, and we are starting to collect people's email addresses for being on an email list. So all of that is diversification, so that if any one of those sources of income goes down, we can focus on others. It's not a great solution, but that's what happens. This is the Wild West of technology here. This is the Wild West of video content creation. If MxR Plays issues a DMCA counter notification and YouTube puts the material back up, the next step is either for Jukin Media to sue or for MxR Plays to sue. Usually it would be Jukin Media suing, but there's already going to be significant damage in that, when you get to that point, to MxR Plays. So they might also go on the offensive and sue first, and ask for either an injunction preventing further damage to their channel while things are going on, because this is really just about money. So why do channels have to be taken down? Why does an entire livelihood have to be eliminated? That's why it's unfair. That's why it's super unfair, is that there's no reason for a channel to be taken down in order to resolve this claim. This claim can be resolved by money. So I do think there's some kind of extortion going on here, when the claim can be resolved by money and they're instead going after the entire channel. I think there's some kind of extortion claim there or something. But extortion is not a civil claim. You don't go to court and say, I want to sue you for extortion. There's other things that represent suing someone for the damages of their extortion, but the actual extortion is a criminal offense. And so if you are really being extorted, you report that to the police or your district attorney or your U.S. attorney. You don't go to court and count on the court going, oh yeah, you've been extorted, so I'm going to award you money. You have to say it differently. You have to find the underlying claim, something like unjust enrichment or violation of a contract or something like that. Jukin Media then can go to court and try to get an injunction or monetary damages against MxR Plays, and MxR Plays can go to court and try to get an injunction or monetary damages against Jukin Media. And whoever is on the right side of the fair use line is going to be the prevailing party in theory. But these things cost a lot of money, and you have to make legal arguments, not just stop at your first thought of, oh yeah, this must be fair use, Judge. That doesn't change anything. It doesn't help anybody. You have to show the judge in a legal proof, A, B, C, D, E, F, G, all the way to Z, A to Z, Amazon, what your legal analysis is in great detail. You don't want to make one minor argument and call it victory. You want to make all the legal arguments in as great a detail as you can afford to do. And the judge doesn't have any duty to do your job for you. The judge gets to sit back, read your legal proofs, and decide which one is more persuasive. because we are in civil court at this point, not criminal court. This is not beyond a reasonable doubt. This is preponderance of the evidence, which means that you have to put on a better case than your opponent. It's like a tug of war. Whoever puts on the best argument and has the best evidence and offers the best testimony, it's a balancing act. Whoever has the best wins. The judge is going to simply sit there, read the parties' pleadings, hear their arguments if there is one. If there's some kind of trial, there'll be a trial on it, and he'll hear the presentations, and then decide whether or not one party did a better job, and that party wins. That's it. Sure, judges can go farther than that, like Judge Catherine Forrest did with H3H3, and make it a precedential opinion, well-reasoned, and everything like that. But remember, H3H3 spent $150,000 or more getting there, making all those arguments, and then the judge takes those arguments, takes their pleading, and looks through all their sources and writes their own opinion based on the winning party's arguments, basically. It's almost, in the best cases for an attorney, for representing, the best cases is where I've written a court order out for the judge, and the judge just has to sign it. So if I can go into court and make legal arguments, and all the judge has to do is agree with me, that's the easiest thing for the judge, and that's the best way to win. If you are writing all of this out and going, I wonder if I'm on the line on this one. Maybe the first fair, was I really transformative? Was I really making a nonprofit educational use, or was I making a commercial use? Did I use the whole video? Did I really usurp the market? If you find yourself on the wrong side of that, then you've got to somehow overcome that against the other party's pleadings, against the other party's arguments. So this becomes a very expensive affair, and only the winning party gets their attorney's fees back. And if MxR plays on the wrong side of it, then they have to pay for Jukin Media's attorney's fees. Well, there's something that we have in the law to stave this off. We have something called an offer of judgment. Even if MxR plays is wrong, they can make what's called an offer of judgment. They make an official offer on the record. The offer itself, the amount of the offer isn't on the record, but the offer, the fact that an offer has been made is on the record, and then the amount comes into it after someone wins or loses. Let me go over it with you. If Jukin Media is right, I'm not saying they are, but if they were right, and if this went to court because MxR Plays issued a counter notification after a DMCA takedown, or just took them to court for the attempted extortion or copyright demand, if that all happened that way, and they were afraid of getting saddled with amazing attorney's fees, they would want to make an offer of judgment right away. An offer of judgment acts to stop the attorney's fees if the offer is sufficient. So you have to make a high enough offer to cover the existing attorney's fees and the existing or the future judgment. The existing attorney's fees and the future judgment. I like that. That's a great way to say that. The existing attorney's fees and a future judgment have to be covered by your offer. Then you are safe, as long as you're willing to pay, of course, the offer that you made. So let's say you made a $3,500 offer. If $3,500 covers the judgment when it eventually gets there, and the attorney's fees up to the point of the offer, so the offer is way in the beginning, the judgment is way at the end, you've now skipped that in the middle. If you get a judgment that is less than the offer at the end, or less than the offer plus the attorney's fees at the beginning, then you don't have to pay any of those attorney's fees in between. So in the H3H3 case, how this would have played out had an offer of judgment been used, Matt Haas could have said in the beginning, I offer to allow, I make an offer of judgment for $5,000 or something. And if H3H3 had not incurred $5,000 of attorney's fees and had not incurred enough of a judgment to clear both the attorney's fees and that judgment in the $5,000, then Matt Haas would only owe them $5,000 and would not have to pay for any further attorney's fees. You could also make an offer of judgment without attorney's fees, at which point you still have to pay those attorney's fees separately, but again, only up to the point of the offer of judgment. This is Federal Rule of Civil Procedure, Rule 68. And I'm not going to go over it, I just want to show it to you. I'm not going to go over it any further. So there's options, is what I'm trying to say. So what should they do? They need an attorney. At this point, they really need an attorney. If $6,000 is on the table, I can virtually guarantee they can find an attorney for, and it's virtually guarantee, not actually guarantee. I can virtually guarantee that they can find an attorney who will talk to them about their rights and maybe even act as a negotiator between these parties and see if they can work it out before anything further has to happen. Maybe they have to pay a little bit of money because it wasn't a fair use, or maybe they stick to their guns and claim that they are making a fair use and that they're going to take Jukin Media to court. That would be something they would want to work out with their own attorneys or attorney. But I would definitely recommend you get an attorney for this kind of situation, as this does feel an awful lot like it is some kind of extortive act, and maybe Jukin Media has damaged their own case by making the offer in this way. Please pay us this fee or else we end your career is a little bit different than we think you've not made a fair use and we'd like to work this out. Here's a demand for money damages. Otherwise, we'll see you in court. The whole threat of, we know that if we issue a DMCA takedown that you'll lose your channel, that sounds like it's over the line for me. But again, extortion is a criminal act, and I don't get to decide whether or not something is a criminal act. The prosecutor decides in their own discretion, which is literally called prosecutorial discretion. The prosecutor gets to decide whether to bring a case against somebody. So we can't automatically say this is extortion. But I mean, we can say it. I don't mean you can't say it. I mean, we can't automatically conclude that a prosecutor will agree that this is extortion. This sounds like a genuine copyright dispute, and it sounds like Jukin Media is being unnecessarily aggressive. And I've heard this other argument then. But, Mr. French, they don't do this to anybody else. Well, yeah, they're allowed to do that. There is no provision in copyright law that says if you don't issue takedowns to one group, you can't issue takedowns to the other group. It certainly sounds like something. That's where maybe people get that from trademark. A trademark has to be enforced against all trademark infringers. Otherwise, you risk, is it dilution or... Oh, I forget exactly what it's called. I have trademark attorneys for this. In copyright, there is no such provision. Not only can they pick and choose who they sue and who they take down, they can allow infringing uses and not take them down. They can also wait 3 years to see how many infringements you accumulate and then sue you for up to 3 years of infringements. Even if they knew about an infringement 2 years and 364 days ago, they can still sue over it. And you can't go into court and claim the doctrine of latches or some kind of delayed response or anything like that. You can't claim that, not successfully. So for example, where do we get that from? There's companies that specifically wait 3 years to see how many infringements you accumulate and then sue you. That's perfectly legal. I don't think it's morally correct, but it's perfectly legal for them to do that. So MxR Plays is in a real pickle here. And I'm not sure it's a pickle of their own making. I think Jukin Media is being unnecessarily aggressive and maybe even illegally aggressive. If I was a defense attorney, and I am, I would definitely be bringing that up in court. That behavior would piss a judge off, I think. That sort of extortive like demand that either pay up or we take down your channel sounds an awful lot like they know they have an unfair balance of power, and they know that YouTube's copyright system works the way it does, and so they're threatening based on money, not based on legal right. If that's the case, then yeah, you take them to court, you call their bluff, and it will not work out very well for Jukin Media. But you only want to do that after you have done a proper legal analysis, due diligence, with an attorney that you've hired who is legally responsible for you and able to give you proper advice. I'm going to give the disclaimer one more time. This is not legal advice. This is not individualized legal advice where I've done my due diligence under the rules of professional conduct and I have attorney-client privilege with someone. No. This is a YouTube video about the laws involved here in the hopes to help people understand what the heck is going on and what legal rights they should be aware of and be looking out for when this happens to them, or just for the entertainment value of understanding what's happening to MxR plays. And that's my presentation. What does Brandon have to say? If Brandon has anything to say. Oh, I have lost Brandon. I see Brandon's bubble going, but I have lost Brandon. Is my thing fall out? No.
Well, that would explain a lot.
There we go.
Apologies. I mentioned, I said a couple things earlier, but you didn't respond. And I was like, oh, he must be really into it. But I guess my microphone just wasn't working. Apologies for that. I don't really have anything to add. You've been really comprehensive in your hour and a half review of this. I agree with you.
Oh my God, we've been going for an hour and a half on this. Wow.
Yeah.
Whew. Let me get the audience back up here because I haven't been able to do both of these things. This will be available. Like, I'm not going to take this down. This will be available.
Yeah, we have 720 people watching.
Thank you very much. Yes, Dilution, says Giga Dramon. Let's see. He's got the documents on Twitter. I think we did look at that. Do we have more documents on Twitter or just the ones that we looked at?
Let me take a look. The ones that we looked at.
So I've
been looking regularly.
And what he says is, here are the charges Jukin Media gave me. $3,000 for a single meme because it contained footage from 2 of their clips. If I don't pay this, they'll strike my channel and take it down. I would say this is the time to get an attorney and see if there is a way to work this out. And then from there, that attorney should do a legal analysis on the exact clips, and it may cost some money. Many attorneys are going to want $2,000 or $3,000 to look into something of this size. So now you start to see the trolly nature of it. Well, wait, Mr. French, $2,000 or $3,000, that's halfway to the $6,000. Yes, that's what they want. That's copyright trolling. That is what pissed off Judge Otis Wright in the Prenda Law case. These claimants literally know or calculate how much of a nuisance value they think they can get out of you. Welcome to the world of legal claims. Welcome to the law. Welcome to copyright. This is the dark side of copyright. This is the injustice of copyright. There should be something in between striking the channel into oblivion and $6,000 for memes. There should be something in between there. But right now there isn't. And I don't know if you're familiar with the political environment we've got going on in the United States. I'm not going to get into which side of it I'm on, but neither side is working together with the other side to pass legislation to overhaul copyright. There is the Case Act, which just sets up a small claims court for this. It doesn't change the amounts involved other than limiting them to $30,000. So it doesn't change the amounts involved in this case. And the Case Act only has passed the House of Representatives. It has not been signed by the Senate. It has not been signed by the President. So that's not going to help anybody right now. What's going to help MxR is to talk to a copyright attorney. It might not even be me. I don't even know that I would be able to do this kind of analysis from where I am. If they wanted to, I'd be happy to talk to them about it and what I'd be able to offer. But they would want to talk to a copyright attorney, and they would want to get someone to do a lawyer, a copyright lawyer, to do a legal analysis of these fair use issues. Maybe they can work out a rate. Contact more than one copyright attorney. Get them working against each other for their rates. Figure out who's got the most that they're going to offer for the best rate. I recently found an attorney who I'm not going to name, but I recently found an attorney who will work for $50 an hour on the contingency that they get to keep all of the attorney's fees if they win. So they get paid $50 an hour by the client, and then if they win, they get attorney's fees at the local court's reasonable rates, which are usually around $250 to $325 an hour. That's a really good payday for the attorney if they win. But these fair use cases are not what I would call a good case for lawyers to take on contingency. The case has to be really an open and shut case for a lawyer to want to take it on contingency. These borderline cases that are in between, your lawyer has to be really confident in themselves or really willing to take the risk. They're going to be putting in a fairly good amount of time. They may have to enter their appearance in a court at some point. They may have to actually physically put on a suit and go to court. And you tell me the last time you wanted to go put on your work clothes and go to work and deal with your boss and do it for free. No, it doesn't happen very often.
Yeah.
So, and these are people who, remember, have studied for many years, at least 3 years of law school plus at least 4 years of bachelor's degree. They then had to go through the bar exam, which is another totally overwhelming thing for people. And then they had to figure out how to practice law, which law school doesn't teach you about. So it's not like these people just got something for nothing and are just sitting on their haunches making money. No, a lot of attorneys have to really grind it out to get to make a living out of it. I, for example, still have massive student loans to pay, and so I'm trying to figure out how to pay them off while not having to actually pay basically a luxury house's worth of payments. And so I'm not going to be able to own said luxury house, right, until I can take care of the student loans. No bank is going to give me a loan for a nice house unless I first take care of the student loan problem. And I've got at least 10 years to take care of that, right? So no, people are not going to want to do it for free unless they've already got all that taken care of, and this seems like an open and shut case for them. So MxR is probably going to have to hire an attorney, probably have to pay them. And so my recommendation is to talk to several copyright attorneys and see who's willing to do the most for the least amount of money, while still being fair to the parties involved, while still being fair to the attorney, not trying to take advantage of some young attorney who's got nothing and needs a break. That could also be a fine thing to do, and I'll leave it to that attorney to decide if that's a good idea or not. But also be careful of underpaying your attorney or giving your attorney no resources to work with, and then wondering why your attorney can't do anything besides talk to you. So there will be costs involved. If MxR sues, there'll be a $400 filing fee in federal court. If Juke and Media sues, at least MxR won't have to pay the filing fee. But for Juke and Media to be suing, hear me out, you got to go through that whole process. There's going to be denial of the $6,000 payment. There's going to be a DMCA takedown. There's going to be a DMCA counter notification. Meanwhile, the channel is taken down. YouTube is not going to be acting very favorably towards MxR, at least not until it gets into the right people's purview. And then, even then you've got the LiveJournal and Cox case situation, where now YouTube, having seen all of this, is on some kind of notice that it exists, and what if they're on the wrong side? So they're probably still not going to be siding with MxR anytime soon. But at least maybe they can look in. At least maybe YouTube can look into it. So what do we do? What do we do? We'll retweet the mother effing heck out of this, because that's how YouTube works, believe it or not. I have an insider now, and YouTube is a Google property in a sense. They're owned by Alphabet, and it uses Google's reporting system. Any Google employee or YouTube employee can go on to a special internal Google portal and report an issue that needs to be assigned triage and go to the right person for processing. And if enough people do that, it goes up and up and up in their system and gets further and further attention. So retweet the heck out of this and tag YouTube and tag Google and ask all your friends who work at Google to file reports on this issue and see if YouTube can do anything about it. That would be the best outcome if YouTube could do something about it. I doubt YouTube's going to do anything about it. But if they do, that would be a good outcome. Otherwise, MxR should get an attorney and figure out whether it's a good idea to pay either this amount or make an offer for a smaller amount. Either wait for the DMCA takedown and then issue a DMCA counter notification, and then after a counter notification, either Jukin Media drops it or it goes to court. In the alternative, MxR could also go to court and start trying to get this resolved as quickly as possible. That's it.
I have a few super chats to read for you.
Go for it.
If you don't mind.
Yes.
That I've come over the stream as you were reading. Nathan McCarty donated $2. That's it. No message.
Thank you, Nathan.
Just, I guess, wanted us to have the money. Taryn858 donated $10 Australian and said that he agrees that the reactions seem somewhat transformative.
They very well could be.
V4L
It's on the line. So I'm definitely not saying it's not transformative. I'm definitely not saying it is not a fair use. I'm saying it is very, very much either a fair use or not a fair use, but it's on the line for me. It's not clearly one or the other without watching more, without seeing the exact examples. And maybe I will privately, and maybe we'll do another video about this later when I have more to say.
Yeah. V4L Grind super chatted 20 Swedish krona saying thanks for the overview. He appreciates it. And then Recore Entertainment donated $1 or $2 USD and said thanks for the 2:30 a.m. copyright live stream.
And I have noticed one of my friends here, Kyle Mahaney, says, how does the YouTube copyright system work if you remove content before someone files a DMCA within their system? That's a really good question. If MxR removed the allegedly infringing videos, I don't know how YouTube treats that. I actually don't. That would be a potential resolution to the issue. Remove the videos so they can't be DMCA taken down. But I don't actually know. I don't actually know how YouTube treats that particular issue. I haven't seen that one come up before. If you take down the video, it certainly doesn't eliminate the underlying claim, but we're not talking about the damage of the claim, are we? None of this is about the claim. It's about the channel. It's about whether YouTube will take down the channel in response to the DMCA claims. Yeah, maybe. This is just a maybe. This is not legal advice, but maybe you do. Maybe you do private the videos or even delete them. See, that's damage, though. There's 600,000 view videos that are still going to be climbing. So it's really just about money. It's really not about taking down the channel, except that that's what Jukin Media has said, and that's what I think pushes it over to illegal extortion, for me, at least. Yeah, it's a terrible situation, Kyle. Yes, somebody can set up a GoFundMe for MxR. I'd prefer it if their attorney set up the GoFundMe, and then we can all tweet the heck out of it, and I'll even make a video about it to help. Guys, we need help. Leonard, my immersion. Real talk, thanks for bringing this up and making this issue known. Yeah, I hope by bringing some light to the issues here, people will understand that the egregiousness of copyright, the injustice of the copyright system as it exists right now. The copyright all by itself seems to take care of the monetary and legal issues, but then YouTube not wanting to be caught up in the safe harbor issue is going to err on the side of caution. And that's what's really creating this. It's YouTube's policies that are creating this opportunity for Jukin Media to extort MxR plays. And that's our show, everyone. So tweet this video out if you want others to see it, but definitely tweet out MxR plays tweets and tag Google, tag YouTube, tag Team YouTube, tag Susan Wojcicki, and that might be enough to get their attention on it. MxR could probably use either some money or just some emotional support that they should go hire a copyright attorney and at least and maybe even vet more than one copyright attorney and see who the best attorney to represent them would be, and that will be the best thing for them. I'm Leonard French, your favorite copyright attorney. Thank you very much for joining me. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Thank you to our $50 plus supporters in the month of January. Thank you to Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Jan Negrey, Spirit Bear, Daniel Perez, Snorre Wisotzky, blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Steven, Cute Grills in your area, and Ottah. And I'll put the $5 plus supporters in the description as well. Thank you all for coming. I am Leonard French, your favorite copyright attorney. Have a good day. I think it's finally day here, so it's going to be day for you here in a couple hours too. I can't stop it. So you'll just have to deal with it.
In a few hours, the sun will rise. I don't know. And somebody might get that reference.
The sun will come up, the moon goes away. Good morning, the little birds say. All of my fellow Eagle Scouts just collectively cringed.
I cringed, and I wasn't even an Eagle Scout. I was just a boy. I was just a Cub Scout.
All right. I love you all. I'll wait for this to go out. Bye.